Claire, can you hear me okay? Great. I'm sorry, we're having technology issues, so my webcam is not cooperating. But thank you for having me on the webinar. And I just wanted to say from the get-go that Aahung doesn't actually work on legal reform. So what I'm going to try and talk a little bit about is the way in which laws and policies have impacted the programs that we've been running on child early and forced marriage, and try to use Pakistan as a case study to showcase the complications that we've seen with laws that have been passed recently around child early and forced marriage. So just to provide some context, there are two key laws that I just want to speak briefly about. One is around sexual behavior within Pakistan, and that actually is just a blanket law. So it doesn't impact young people any differently from anyone else. Sex outside marriage is seen as a criminal offense, and is not allowed under any legal circumstances, consensual or not. The second law has to do with specifically with early and forced marriage. So up until 2011, Pakistan operated under a federal government and a federal set of legal regulations. And under that, girls were permitted to marry by the age of 16, and for boys it was 18. In 2013, there was a devolution of the federal government. So provinces were allowed to develop their own legal requirements. And in 2013, what we saw in the province of Sindh, which is where Aahung is situated and does a majority of its program work, was the passing of the Child Marriage Restraint Act of Sindh. And very briefly, what the act did was it changed the age of marriage, minimum age of marriage for girls to 18 as well. It also stipulated that guardians would be penalized and punished if they allowed marriages for anybody under 18. And it also put in particular measures for anybody who performed or conducted such marriages as well. It does not penalize minors. However, if there is a 18-year-old boy, for example, who marries a 17-year-old girl, the 18-year-old can be that can be seen as a criminal offense, and the 18-year-old, held accordingly. So this law was passed with a lot of joy, and it was seen as one of the first stance that the government had taken to try and equalize boys and girls and to provide greater protective measures for girls in the country. We've had a few years to review it and to analyze it, and what I'd like to do is actually break down the analysis into three parts. One being practical, the second being rights-based, and the third being how it's really impacted our programs and what we've really seen happen on the ground with this law. So on a practical note, the first thing is the disconnect with the law, between the law and what we can do in terms of implementation. So we don't register a majority of births in Pakistan. 42% of births are registered. A majority of births do not take place in hospitals. So when we say that we're going to put down an age, a minimum age of marriage, already we can foresee the complexities around this, because we don't actually know how old children are in this country. So that's right off the bat. The second implementation issue that we've had is that the people who administer marriages under what we call the marriage contract, which is the nikah, they're called nikahwaz, and they operate at the community level. They are not administered by a single body, and it's very difficult to actually know who is a nikahwa, who is registered, and where they are performing marriages. On top of which, there is a loophole in the law which allows for anybody administering the marriage, if they don't have proof or evidence that the girl is not of 18 years of age, then they can't actually be held accountable. So when we don't have birth registration, that makes it very easy to access that loophole. The third problem was actually the weak infrastructure of the country. So we have a number of issues with all laws actually in terms of implementing them. We have a weak police force, a great deal of corruption, and actually a complex judicial system. And what we've seen with regards to this is that there have been cases that have gone forward, but particularly in the lower courts, what judges have done is they've resorted to Sharia or Islamic law, which quotes that marriage should technically be allowed at the age of puberty. The Child Marriage Restraint Act should trump that, but because there's nobody challenging these cases, it has not actually panned out very well within the judicial system itself. And what it's really showing is that there's a lot of contention around this law, that it has not been well received, which is perhaps the larger problem. So in terms of the practical outcomes, what we're still seeing is about 21% of girls in the country being married under the age of 18. And where we've seen certain improvements in that in urban centers, it doesn't look like the law has really been the key to those changes. On a rights level, what are we seeing? Well, firstly, we're seeing this problem around the denial of anybody under the age of 18 taking control of their own choices around sexual behavior and around their marital status. There is, of course, a great deal of controversy between what a child does and does not have the capacity to do, and under the umbrella of child protection, there's a case that can of course be made around protecting children from sexual abuse and also from forced marriage. But looking at the evidence, what we're seeing is that this law is not actually serving to protect children from those things. What's actually happening is that it's being used often by families to challenge free will marriages. And those free will marriages are often happening in circumstances where there's either abuse in the home or girls are being forced into marriages that they do not want. So they're trying to marry out of free will under the age of 18, but families are using this law to actually prevent that. So we're not seeing it serve the protective purpose that the intention of the law was made with. So where has this all led to in terms of our programs? We've seen a few challenges. The first one is that the black and white nature of the law, which is to cut off at 18 years of age, has resulted in a lack of nuance in some of the programming. So where we need to look at every individual's circumstances, and we need to look at girls as individuals who have the potential of education, of economic success, of potential, of their own rights, it starts to become an issue of, well, are they 18 or are they not 18? And that often also really starts to boil it down to the simple issue of health-based outcomes, which I think can have really negative effects on programming. The other thing that we've started to see is that there's a lot of complacency sometimes when these laws are passed. So rather than really starting to assess the driving forces behind these, the gender discrimination, social, economic, cultural, religious driving forces behind something like child early and forced marriage, there starts to be a reliance on the law as the protective factor which will sort out the problem. So this also starts to beg the question of what really are the driving forces for legal change, and where is the accountability? So when we go in with program interventions that are pushing for laws, where is that actually needs-based? Is that the need that is coming out at the local level, at the community level? Or are there global actors, the influence of funding, as well as local actors that are making assumptions about what changes in laws are going to do, that actually end up pushing for things that are not having an impact, and perhaps in some cases are being hurtful at the local level. So given all of these circumstances, for me, the consideration is less about laws versus no laws. It's more about how laws can be nuanced and more reflective. Yes, in many circumstances, we do need those laws to hold the state accountable, to have a base, a foundation that we're working on, which shows that there's an expectation around the protection of certain rights. But looking at the child early enforced marriage law in Pakistan as an example, where those laws are not needs-based, where they're not nuanced, where they're not practical in terms of implementation, and where they are only looking at punishment as the driver for social change and ignoring all of the other factors that are key drivers as well, we are really not seeing change. What we're seeing, in fact, is a further violation of rights. So I think a careful analysis of how laws can be smarter really needs to be done, particularly when there's a lot of contention around protective laws. And in this case, of course, with children involved, that inevitably happens. So that is my piece on the child early enforced marriage. Thank you.